Thanks for joining us today. I'm Andrew Villafranca, Director of Financial Planning and Wealth Advisor with Boggs & Company Wealth Management. As part of our quarterly webinar series, the Boggs team and I thought that it would be helpful and appropriate to discuss estate planning. Creating or reviewing your estate plan is important as we approach the end of the year and plan for 2026. Remember, your estate plan dictates how you want your assets transferred to future generations, and it's imperative to have this done correctly. Done incorrectly, your property and your money could end up in the wrong hands, taxed at higher rates, or in worst cases, destroy personal relationships. As our clients' financial advisors, we do a deep dive into estate plans to ensure that our clients' wishes and desires are clearly communicated. However, we're not the ones creating the actual documents, so we need someone special for that. Joining me today is someone who can speak on her experience as an estate planner. So I welcome Lindsay Warnes. Hi, Lindsay.
Hi, Andrew. Thanks so much for having me today.
Thank you. Thank you. So just to give our viewers some background on Lindsay, she's the founder and senior attorney at Willow Legal Group, a Maryland-based law firm. Her office is in Laytonsville, Maryland, so she's local to Montgomery County. She's been practicing law since 2008, and in 2016, she switched her focus to trusts and estates. I've got to know Lindsay, so she'll help lead today's webinar. Fun fact, aside from being a wife and a mother, she is a big Ohio State Buckeyes football fan. I am so sorry about last weekend.
All right. Could have been worse.
So when Lindsay and I got together and discussed doing a webinar, we wanted to change things up. So we're going to do a different format today. Instead of your typical webinar or seminar or presentation, we wanted to make today a conversation. We're going to go easy or little on the slides, little on the charts, no graphs. So Lindsay's going to share some estate planning insight via stories and anecdotes from her experience. I do want to mention one other note. For those of you who couldn't tune in, there's going to be a recording of today. So once that link is ready, we'll send it to you. You can rewatch it in the future. And also, if you have any other family friends or friends who are interested in this topic, please feel free to share it. So, Lindsay, I know estate planning, just like investing, it's not the most extravagant of topics, but it's certainly easy to overlook. Why is it important for families to address their estate plans now?
I think the biggest thing that we like to focus on is just control, because part of estate planning, yes, of course, it's who gets my stuff when I pass away, but there's really a lot more to it than that. A lot of it is sure what happens when you pass, but then what happens if you can no longer manage your affairs while you're living. And so having that whole picture and all of the documents to support your wishes keeps you in control of what you want done and how you want things handled, to avoid court intervention where possible. And also, if you have little kids, minor children, you want to make sure you have somebody set up to take care of them if you and your spouse or their other parent cannot. So just really making sure that your wishes are honored, both during your life if you can't manage your affairs, but also after you pass away, and making things easy for your loved ones, because they are the ones that have to deal with your mess or not. So really it's about control, and we say leaving a legacy of calm, because you don't want your family to hate you for not having your affairs in order. You want them to, miss you and be sorry that you're gone. So.
Yeah, and it could be a tough topic to address too.
Yeah.
One question I always think of when we ask you, what do you say to people who think that they can do this by themselves? I know there's resources online. There's LegalZoom. There's Trust or Will or trustandwill.com. I remember Matt Stafford is in one of those commercials. But what do you say to that person or that family?
I say, please don't. There are tons. Yes, there's LegalZoom, Susie Orman, Mama Bear, Will and Trust. There's just tons out there. And Andrew and I were talking a little bit ago about AI, and people are trying to do stuff with AI. And the issue with these is you don't know what you don't know. And the reason that you want to talk to an estate planning attorney is because you may come in and say, okay, well, I have a simple estate. I just need a simple will. I want to leave everything to my adult children, blah, blah, blah. And so then I start asking questions. And I will hear, well, I never thought of that. Oh, I never thought of that. And it's because you just don't know what you don't know. And so the problem with these online tools is they are not going to do a deeper dive with you. They're not going to counsel you. They are going to have a checkbox. Do you have adult children? Do you have minor children? Are you married? What are your assets? Who do you want to leave them to? They're not going to walk you through, okay, but what if your two adult children who you're leaving your house to, one wants to sell it and one doesn't? Like, what happens then? And what is the legal status of their ownership at that point? And so there's all these different things to consider that if you just check boxes are not going to be considered. And then what we see is once you've passed and your family's going through the probate process, there is just fighting and chaos and unnecessary expenses and potential litigation. And now brother and sister hate each other and they hate you because you didn't spell things out. So that's the problem we see with the DIY stuff. Oftentimes people are like, well, is an online will legal? And yeah, if you sign it correctly, it is. But I think the proper question is this really have the outcome that I want rather than is it legal? So please don't, is what I tell people.
I love your honesty. I see it too. My team sees it too. We'll take on a client who likes to invest on their own. They'll use a Fidelity or a Vanguard. They love it because it's cheap. But when they have questions about the more nuanced aspects, AI or Vanguard or Fidelity, you have to rely on a call center, right? So I get it. That's why your review, that's why people reach out to you and need you. So completely understand. I was just curious. Another thing I was curious, and let's do story time. So my two questions, can you share one of your client's success stories? And then on the other hand, can you share one of the worst client stories that you've encountered?
Um, yeah, it might be easier to share the what not to do horror story first, and then how we help people avoid that. So I mentioned probate earlier, and for any of you who don't know what probate is, that is the court process that happens when somebody passes away. Any assets you own in your individual name have to go through the court process. And in Maryland, even if it's a dollar, it technically needs to go through the court process. Other states don't have that requirement for small estates, but we do here. Um, and this is something that doesn't have a beneficiary. We can talk about that later. But we're talking about probate. So I have a current probate. The woman did her own will, and we filed it in the court. And when we got there to file it, my client is the executor. In Maryland, we call it personal representative. And we got there to file the paperwork, and the court said, oh, somebody already filed a paper. We're like, well, who? She doesn't have any family except her brother who's been in prison for years. Well, he had gotten out 2 months prior and filed a petition to open an estate and act as the personal representative, not knowing she had a will. And so that started the litigation process. Probate is slow, litigation is slower. And so fast forward a bunch of hurdles. It took us 3 years to get my client appointed as the personal representative and the will admitted. Um, and during that time, her house went into foreclosure. We had to stop that because there's no access to her bank accounts. Okay. So she didn't have a spouse or children. And then her parents had both predeceased. She owned real estate that she had inherited from her father, as well as owned on her own in both Virginia and Maryland. So we have separate probates in both states. It has just become a really, really, really long and horrible process. And it's not common in the sense that not everybody has a brother who just got out of prison who wants to cause problems. This particular estate has that. But even without that, her will is ambiguous. She did it herself. And so she left the same real estate to multiple people. So now we have to get that figured out. So it's just more litigation, her thinking she did the right thing. How would we avoid that? So this is what we do for clients, and these are our success stories. We help them avoid probate. First of all, with somebody like her who owns real estate in 2 different states, we would recommend a revocable living trust. So what that is it's a document where we then, it's a contract essentially. The person who owns the assets is also the trustee and the beneficiary during their lifetime. So they can still control and manage their own estate. They can manage their own affairs. Nothing really changes. It's just renaming of assets. But then when she passes away, there's nothing to go through probate because the trust owns it, because it's a separate entity. So we would have had her do that so that, one, there would not have been probate. Probate is public. So everything that we file, her brother gets notice of, and he opposes and appeals. And that's why this is taking forever. Trusts are private. So if she would have come to us beforehand and done a trust, we would say to him, I'm so sorry, you're not a beneficiary. You have no business knowing any of this. And this process would have been over by now. The other thing that she did incorrectly was in her will, she tried to say, I revoke my beneficiary designations on my 401k. You can't do that in a will. Those pass outside of the will. So you want to double check your beneficiary designations. Make sure that you have one. Make sure it is somebody that you want to receive that money because you can't do anything about it after you've passed. We would have worked with her on who to name because what she wanted was her estate to receive the money. Instead, she named nobody, and now her brother is getting it because that's the policy of the account holder. And so that wasn't her intention. In her will, she wanted to create a foundation. And if she would have done a trust, that would have all been set up. And so there's just really everything that you can think of that could go wrong with a do-it-yourself plan has gone wrong. And we would have fixed that just by counseling her on those things. Real estate, out-of-state property, beneficiary designations. Who do you actually want in charge of things? What do you want this foundation to look like? Oh, by the way, you can't leave the same property to 5 different people. So we would have gone through all of those things. So our success stories are really with those clients. And I have had, unfortunately, several who we've worked with who have passed since working with them. And because we know their family, they know to call us. They are able to say, okay, mom passed away. What do we do? And so it's a lot easier to say, well, we have a trust. So here's what you do. Or your mom did do a will. We don't always do trusts. I know people ask, is a trust for everybody? It depends. But then we can counsel them and we have a relationship with them and it just makes the process a lot smoother.
You are spot on, and you beat me to it because that was one of my next questions. People asking, does everyone need a trust? And like most things, sure, it depends.
Yeah.
Oh, it's interesting. Why do you think, well, this also affects me too, because investing, financial planning, people drag their feet, right? Why do people drag their feet when addressing or creating or even reviewing an estate plan? It's so important, but why do people delay? Procrastinate?
Yes, the main thing we hear, so I think it's obviously nobody wants to think about their death. It's the one thing that is inevitable for every single one of us, but nobody wants to think about it, which I get. I think another thing is, well, I don't know who I would name. So we have a lot of parents that come to us and they have minor children and they say, we've been wanting to get this done since our kids were little, but we don't know who we would name as the guardian. And so we've done nothing. And I think it paralyzes people if they don't have all the answers. And so they don't want to come to us because they're like, well, I don't know who I would pick. And our job is to help figure that out and maybe think of people that they hadn't considered before. And so I think that's one of the reasons. We do hear sometimes that people truly believe that if they do a plan, then they're going to get hit by a bus. And I tell them I've never seen that happen, but wouldn't you rather have a plan and then get hit by a bus rather than not have a plan? Other common misconceptions are, I don't have enough assets. You all have assets, you all have something, you all own something, and you all have people that you care about. Or I'm married and my spouse is just going to get everything anyway. And that's not always the case. It really depends on what you have, how it's titled, and the law. So it's not an automatic. Now they might get it eventually, but you might have to go through probate, or they might be splitting it with your children, depending on the circumstances. So I think those are like the main reasons that we hear is as why they've waited or why they just drag their feet.
Mm. Yeah, it's I like to say to my clients, I wear another hat where I am a follow-up person.
Yeah.
And some of them are very appreciative of that because they would say, "Oh, I forgot I need to do that." And no, thanks for sharing. Another thought that came to mind that overlaps is, what are your thoughts on those who have a trust as a beneficiary of their island?
I think as long as it's done properly and the language in the trust is correct, it's not an issue. And we do that often for minor children. Minor children can't inherit until obviously till they're adults. And so if you name a minor child as a beneficiary on an account and it's just them as an individual, then the law says that a special account has to be set up for them to receive it. And in Maryland, those account the UTMA or UGMA accounts, which I'm sure you're familiar with, universal gift or transfer to minors. They vest at 21, and that is when they get their money. And if we're talking about a large estate, you might not want a 21-year-old inheriting $5 million. So what we recommend most of the time is you set up a trust and then you can name the trust as the beneficiary after the spouse, if there's a spouse, because Secure Act. But the trust needs to have language in it that doesn't interfere with the Secure Act. And the Secure Act, you can talk more about it if you want, but that's just an IRS rule for inherited IRAs and 401ks that says there's a certain amount of time that you have to withdraw funds. And if you don't do it properly, it could go from 10 years to 5 years. So you want to work with somebody who knows what they're doing. So, so I like it a lot of the time as long as the trust is set up properly.
Got it. Yeah, we're still, I call it adjusting to the 10-year rule. Like you said, it could go to 5 years if this process isn't done incorrectly. And imagine those clients, investors with high incomes, right?
Mhm.
They inherit $1 million, $2 million IRA, and they have to complete that within 10 years.
Right.
Their tax bracket or those tax payments, those are pretty substantial. So that's definitely something that we try to help our clients manage. I know you, getting to know you, you told me how your practice works, and you likely have a different process than other law firms, but you certainly have a thriving business. What's your process when it comes to working with a client? Can you walk us step by step?
Sure. So it starts with an initial call to get on our calendar. Myself and my partner Megan do all of our initial strategy sessions. And that's where we ask you to do a little homework. We want to know a little bit about you, your family, what types of assets you have, how they're titled, and then just a general idea of how much you have, because there are taxes that we might need to discuss depending on your assets. And so we go through that meeting talking about that, but also what are your goals? And so Megan and I are very goals based. And so this kind of goes back to that question of does everybody need a trust? The answer is it depends on your goals. We talk to people often that say, well, I talked to this other attorney and they said I have less than $1 million, so I don't need a trust. And I said, yeah, but you have a house. Do you want it to go through probate? If you don't, then you need a trust. And so it's not necessarily what you have, it's what are your goals? And so we talk about all of those things. And then at the end of that meeting, we're going to work with you to make a recommendation and decide what works best for you. If you decide to move forward with us, we'll schedule a second meeting where we go in and actually put the pieces together. These are the people that I want in these different roles. This is how I want my plan set up. I want my kids to inherit, whatever that looks like for you. We will schedule our design or our signing meeting. And then our signing takes place 4 to 6 weeks later. We try to keep the process kind of moving because, again, well, life is busy. And we know that if we don't keep you on track, you're going to be like, oh, I'll get to it eventually. And then we're never going to see you again. And we don't want something bad to happen when you've started a plan. I have seen so many unsigned documents of people who've passed away. And I'm just like, well, that's worthless. And so we want to keep everything moving. So our process is roughly, 8 weeks from that first initial call to your signing. We keep copies of all of your documents, and then we follow up with you every 3 years just to check in. Life changes, right? Your estate plan is a living, breathing plan. And it shouldn't be you did your plan and you don't even look at it again for 30 years because the law is going to change, your life's going to change. And so we just want to check in every 3 years to see what's new. Do we need to do anything? If not, great. How are the kids? How's the retirement? Whatever it is. Um, and then we'll check in with you again in 3 years. Unless there's a major life event, we would like you to let us know. Um, but yeah, so that's kind of our process.
So, good wording, life events. It might seem simple, but there's so many.
Mhm.
What are common life events that you recommend where people should actually focus on estate planning?
The two main ones, maybe three, marriage and divorce, because the death laws for probate and estates are very different than divorce laws. And so legal spouses are entitled to your assets, a portion of your assets. So if you get married after you plan, or if you get divorced, we need to look at that. Um, if you have children. Now, if you have multiple children, we tend to put stuff in our plan that says it includes any afterborn children. So you don't necessarily have to update, but if you have no children when you make your plan and then you have children, we'll probably want to provide for them. Um, and then there's other life events. If you come into a windfall of money, whether you receive a large inheritance or win the lottery, because we all hope for that. We want to talk to you about it, and then you'll have a team also, but we want to talk to you about tax planning. And that's when we get financial advisors and CPAs involved in those conversations because there are special rules for our wealthy clients. Um, death death may or may not be a life event that requires changing, to be honest. It just depends. We build in contingencies in all of our plans so that we've got backups named. Certainly, if somebody in your plan has special needs, we want to address that. So, really, there are some key ones, but they might not always require updates. But check in for basically it's birth, death, marriage, divorce, asset changes. At least check in.
And that's the interesting part to me about your world is there should be an ongoing relationship, just like with your financial advisor, right? If you still talk to your estate planner, and it doesn't have to be every month, right? Once a year, maybe once every 2 years. But when I meet with a client and they show me their estate plan at the initial meeting, I haven't seen it updated in 10 years.
Yeah.
And they've probably had two kids, they have a grandchild who they want to leave money to, or they have two other properties they just bought, and nothing is on trust. Also, another horror story is finding out that there is a trust out there and it's not even funded.
Uh,
So, advice for the audience: please make sure your trusts are funded and the titling is done correctly.
yes.
That is one of my takeaways. So knowing you're based in Maryland,
Mhm.
what are some nuanced rules that residents in Maryland should know about when it comes to estate planning?
So there's a couple that Maryland has that not all states have. One is inheritance tax. So there's only a handful of states that still have this, and it really only affects people who want to leave assets to someone who's not a direct relative. So if your plan involves leaving assets to your spouse, your parents, your children, your siblings, they would not have to pay inheritance tax. But if you want to leave assets to anybody else outside of those people, they're going to be subject to a 10 or 11% inheritance tax on what they receive. This is, it's a problem for people who don't have kids or who are not married and don't have kids. And I hate it. And every couple years it comes up to be repealed, and the legislature keeps not repealing it. There's no legal way around it, even with a trust, because by law it's supposed to be reported unless you commit perjury, which I like my law license, so I am not ever going to do that. Um, but it's just one of those quirky things that like Virginia doesn't have, and many of the surrounding states don't have. Maryland also has a state level estate tax. So there's a federal level, which is about $15 million a person, double that for married couples. If you have assets below that limit, you don't really have to worry. If it's above, then you're going to pay when you die, your estate will pay a tax on whatever's above that limit. Maryland's is currently 5 million per person, 10 million for a married couple. Um, Other states don't have that, or other states might be higher or lower. So there's little quirky things And then, of course, there's always your state-specific intestate rules, meaning you have no plan at all and you die without a will or a trust, who gets your assets. And Maryland's is different than a lot of states where, depending on the circumstances, your spouse could be sharing assets with your children. So those are the main ones I think that I see.
Hmm, interesting. You mentioned your process. So what is the most common client issue you see during your meetings?
Most most common issue, just that they've been meaning to do it and haven't. And we always want to know what prompted them to do it now. And I think it's usually something happened to someone they know, and they're like, "Oh crap, now we have to do our planning." Like we can't, there's a reminder of their mortality, whether it's a parent passes away or becomes incapacitated or their neighbor, it's something happened and they say we need to move this forward now. Um, it's either that or we did our plan 30 years ago when our kids were minors and now they're grown and it's probably time to look at this again. Or my financial advisor has been yelling at me to come do this. So that's probably the most common things we see.
Gotcha. I was thinking we play a little game. I'm probably watching too many or listening to too many podcasts, but we do have some questions that filtered in before.
Mhm.
Some of our audience wanted to send in questions, and I'm interested to hear your thoughts. By the way, I just want to thank Lindsay again. She's been amazing. We could talk for hours. Again, Lindsay Warnes, Willow Legal Group in Laytonsville, Maryland. Again, there will also be a webinar link if those who wanted to watch it can watch it. You can also share the link around with family or friends. But here's some Q&A. We'll make it, I wouldn't say rapid fire, but again, share like you have been. What is one lesser known strategy that families should consider when they're creating their estate plans?
I would have to say the revocable living trust, and it's becoming more common because more people are talking about it. But that is one of those things that should be considered at least by everyone to see if it's a good fit for them. It saves a lot of headache, a lot of hassle, avoiding the probate process, assuming it's properly funded, like you mentioned. Um, but it's something that I tell people, wealthy people have been doing this for years. Regular people are now starting to catch on and realizing, hey, we can do this too. So I really think they should be considered, even if it's not right for the situation.
Got it. I do have a follow-up question, probably related, and let me know what to move on. There's one that's asking, what is one overlooked area in your average estate plan?
Um, so I think ensuring liquidity for final expenses, because avoiding probate's great. But you do have final expenses when you pass away, primarily funeral. And so if there's no cash available somewhere, if we haven't thought through that process, somebody's coming out of pocket for that. As well as, there's a final tax return that has to be filed. Like there are final expenses, even if you don't have debt per se. And so just ensuring that you don't just put beneficiaries on everything just to avoid probate, that we have thought through, well, who's going to pay these expenses if your estate can't, or everything's tied up in real estate or whatever, or 401ks or whatever it looks like. So um, that's one of those things that I think nobody really thinks about. It's all let's avoid probate, but let's also look at the practical side of things.
I think a lot of people out there read about when, like, remember when was it Michael Jackson passed away? Now there was a whole fight over his estate, just other
Yeah.
celebrities, and again, like we talked about, it can get really messy. So
Mhm.
yeah, I agree with you there. The last question I have: what are your thoughts, Lindsay, on state tax rules or the estate planning environment in the future? Tell me about your crystal ball.
Well, as long as this administration is in office, there will not be any reductions in estate taxes. But I think that the estate planning environment, I think more people, since COVID actually, have been really pushing to get their planning done because we're seeing more uncertainty. And people, while living longer, And that's a whole other side of estate planning, the elder law long-term care planning side. But people are living longer, and so they need to plan for that care for when they're in, if they need individualized care, but also realizing that things can happen at a younger age. And so I think estate planning is becoming more top of mind, and it's less taboo, I guess. And that's one of my goals is like, let's talk about this. We're all going to die one day. Like, let's not make it some weird thing that we can't talk about.
Gotcha. And then the last question is, who wouldn't want to create an estate plan like that?
Who wouldn't want
Who
to?
wouldn't? Yeah. What kind of person or what kind of individual family? Yeah, this is an interesting one.
I've actually talked to people who have said, I'm dead, I don't care. To me, that seems short-sighted and selfish because, again, you're dead, but if you have left a terrible mess for your loved ones, like, I think that's just very selfish.
Yeah.
And maybe that's harsh for me to say, but I look at estate planning as a gift you give to the people you care about.
Yeah.
So,
In the spirit of the holiday season, right? Why would you want to do that?
right, right. Like, why wouldn't you want to like make things easy for them? I mean, they're already grieving your loss. Why make them jump through all these hoops?
No, you have a tough job. I mean, we talked about before this webinar, it's the empathy, right? That
Hmm.
you're able to show your clients, and that's why they stay with you. That's why they rely on you. So something certainly I believe AI cannot replace, or at least hasn't proven it, right? So folks
Right.
want a human. So very good.
Agreed.
But that's all the questions that I received, and you've
Okay.
done a fantastic job
Oh, well, thank
covering our topic today. I just want to say thank you. Thank you to your team. I'm hoping the end of the year goes well for you. And I also want to thank the LPL webinar team for helping put this together. Thank you to our viewers who joined. I'm looking forward to many more webinars in 2026. So on behalf of the Boggs and Company team, we wish you a happy holiday season and a happy new year. See you in 2026.